Okay, welcome everyone. Thank you for joining us today, both at the School of Advanced Study in Senate House, and for those of us who are joining online, you're very welcome. My name is Corinne Lennox. I'm a professor in Human Rights and International Relations based in the Institute of Commonwealth Studies at the School of Advanced Study here. We're also organizing this event under the auspices of the Human Rights Consortium, which brings together the human rights researchers across the School of Advanced Study and more internationally. And the Minority Rights Solidarity Network, which is an organization started a few years ago to bring together academics working in defense of minority rights with activists also working in defense of minority rights. So we're pleased to be able to bring scholars and practitioners together through that umbrella of the Minority Rights Solidarity Network. Tonight I'm very pleased to be able to welcome Professor John Packer for his talk on the legal obligation for genocide prevention. When we posted this event, and I was grateful to colleagues, in particular Sally Holt, who suggested we host this, we had about a week and a half to bring it together, but in that time we had 100 people sign up who want to hear about this talk, and it's great to see so many familiar names and online as well who are joining us. So I think it shows obviously how much genocide is in the headlines at this moment, but also how much it's in our hearts, and how obviously the situation in Gaza, the genocide in Gaza, the resurgence of what we can see as genocidal practices in Sudan means that it is an ever-present challenge for the international community, but also obviously for suffering of particular targeted communities. So we welcome the opportunity to hear John's reflections on this from a legal perspective. If I may say a few words about his own background, he is Associate Professor of Law at the University of Ottawa in Canada. From 2018 to 2025, he was the inaugural Neuberger Jessen Professor of International Conflict Resolution in the Faculty of Law at the University of Ottawa, and previously was the Director of the Human Rights Research and Education Center at Ottawa, University of Ottawa. He's held appointments at many intergovernmental organizations, UNHCR, ILO, Office of High Commissioner for Human Rights, Department of Peacekeeping, Political and Peace-Building Affairs, which I actually had to look that one up with the DPPA, and the OSCE, where, amongst other things, he worked with the High Commissioner on National Minorities. And through those roles, he has investigated serious human rights violations and has advised on peace mediations and political transitions, including constitutional and legal reforms in over 50 countries, especially in relation to intense intercommunity disputes. Since 2022, he has been the special advisor to the Joint Conciliation Resources and Sasakawa, thank you, Peace Foundation project on mediating self-determination conflicts. He is a member of the International Expert Group on Peace for Ukraine and a member of the Canadian Government's Standing Table on Human Rights. And he has investigated and advised on major reports on genocides in Iraq and against the Rohingya, Uyghur, Ukrainians, Iranians, amongst others. I'm going to invite John to speak for about 45 minutes. We will have, this part of this session will be recorded, so that will be available for folks to consult online, and that will be made available on our website at the Institute of Commonwealth Studies. And then I'll invite our discussant, Professor Damien Short, who's also joining us. I'll introduce him at the appropriate time. And then we'll open up to questions, and the questions won't be recorded, so we'll have a free discussion space. For those who do want to ask questions online, we do welcome that. I'll be looking after this desk to try and capture some of your questions and comments as well. But without further ado, welcome, John, and please, you have the floor.
Thank you. So the microphone picks up anyway?
Yes,
okay.
In the ceiling.
Microphone's in the ceiling. Okay, thank you. So thank you very much, Professor Lennox. It's a great honor and a great pleasure to be back here at the University of London. Also, let me also congratulate the Institute of Commonwealth Studies for the Human Rights Program, which is 25 years?
30 years.
30 years? Sorry, short changing you 5 years. And I recall also its origins and all the efforts that have been made over the years and your both of your contributions throughout that period. So congratulations on that. I will take the opportunity also talking about anniversaries, just to note a friend and colleague in the room, Jamie Burton, who's one of the co-founders of Just Fair, and they have their 15th anniversary here in the UK. And I would love to see a lot more Just Fairs established in other countries that deal with economic, social, and cultural rights, which I think in our day are of increasing urgency. I'm going to talk about, some might say, the other end of the spectrum than economic, social, and cultural rights, although not necessarily. You'll see the link, about genocide. And I want to observe a couple things about this. First of all, it might escape people, but it's not a coincidence that the Genocide Convention was adopted on the 9th of December, 1948, one day before the Universal Declaration of Human Rights. The people in the room were involved in both of those processes, were totally cognizant of what they were doing, and all of that, of course, was proceeding from the Charter of the United Nations, which begins at in order to save succeeding generations from the scourge of war, which twice in our lifetime had affected us, that generation. So this linkage is not coincidental or incidental, it is purposeful. And I think you should think about the topic of genocide as kind of one end of a spectrum, to kind of underline this is what should not happen. And on the other side of that coin, or end of the spectrum in the Universal Declaration of Rights, a vision of, therefore, how do we live together in universal respect and mutual respect and sustainable peace and development. Now, in that, the essence of the concept of and the norm with regard to genocide was from the start encapsulated by this slogan, which is not in the Genocide Convention, but is popularized, which is never again. And therefore, the idea of never again is a preventative, or something which is foreseeable. We have a knowledge and an experience of the past, and we seek that this should not repeat itself. And this is articulated not in the term never again, but explicitly in Article 1 of the Genocide Convention, which is obviously a separate provision of a fairly short instrument. The Genocide Convention has 9 operative paragraphs, or articles, in which it obliges states under the duty to prevent genocide. This has been adjudicated by the International Court of Justice as a distinct obligation from the prohibitions of conduct under Article 2 and the requirements, and also under Article 3. Article 2 are the acts of genocide, and Article 3, which are the associated acts of complicity, incitement, attempt, and so forth. There are other provisions of the Genocide Convention which I wish to underline, which are very important, not least the duty, for example, to incorporate in domestic law the prohibition and the prescription in domestic law, of which not all states have done, even states parties to the Genocide Convention. And within this, you can start to see an important distinction that's made within the convention, which is the distinction of its primary obligations, which are undertakings of states, and duties to hold individuals to account. So the convention, which is about prevention and also prosecution, that distinction, the prosecution element, we must immediately gather is with regard to individuals who would incur individual responsibility for breaches that should be prohibited by domestic and international law, which is now the case. Okay, so I'm going to say a few things about how we can better understand this very primary instrument of the post-Second World War public international order, or contemporary international law, the Genocide Convention. And I'm going to say a few prefatory remarks beyond what I just shared, and then I'm going to go a bit more into the convention itself. So we can go into the second slide. Oh, I can do this. Do I just click it, or?
Should be, yeah.
Oh, no. What do I do? Roll it? Nope. Let's see. There we go. Okay. So, notwithstanding the idea and the commitment to never again, we can see in the popular media, and if you're just kind of following world events, there's been an uptick, to be quaint about it, in the number of situations that are prima facie violations of genocide, or incur acts of genocide, or incitement, and so forth. So we're living in an era where, unfortunately, instead of the diminution, we actually see a resurgence of such situations. That alone, I would say, speaks to a kind of failure of the initial idea, the never again idea. What I'm going to talk about now, though, is not the popularized idea, which is very much misunderstood, and including in political quarters and elsewhere. I'm going to just talk about the law. I'm not even going to talk about the ethics, just the law. And in this, I'm going to talk about the positive law, which is to say the really existing express articulation international law, which forms part of contemporary international law. So some people talk about, and I don't want to get into the situations, historical cases and so forth and so on. I'm talking about the treaty, or we can talk about some treaties, because we will mention the Rome Statute in a moment. But I'm mainly talking about the 1948 Convention. Now, quickly to remember that if we're talking about positive international law, this is not a secret or complex thing. In the sources of international law, there are basically only three sources: treaties, custom, and general principles. You will hear often, if you take courses on that, about the subsidiary means. I wish to underline the word subsidiary. In public international, there are basically three sources. If you don't have one of those three sources, then it doesn't really matter what the subsidiary part is. You have to have a primary or a principal source. And within that, the clearest is, of course, treaty. And within treaty, we happen to have not only this treaty, the Genocide Convention, a short, fairly straightforward treaty, but we have the tremendous benefit of another treaty called the Vienna Convention on the Law of Treaties, which tells us, and when it was adopted in 1969, not only is itself a treaty, but it was purposefully an articulation of, or a codification of customary international law, the International Law Commission's work on that, and a development to contemporary era, which was then accepted as binding by the states parties, virtually every state party of the Vienna Convention on Treaties. Within that convention, it not only tells us what a treaty is, it tells us how to interpret a treaty. And I wish to underline this, because there's a lot of stuff written about what the Genocide Convention says or doesn't say, no reference whatsoever to the Vienna Convention on Law of Treaties. In other words, people ascribe to themselves speculative ideas, or I think it means this, I think it means that. That is not positive law, international law. That's just sometimes wishful thinking, sometimes popularized ideas, and I'll give you examples of that in a moment. I'm going to stick with the hard positive law, Vienna Convention on Law of Treaties, interpretations of the Genocide Convention. The Rome Statute is also a treaty, but the Rome Statute, and very important distinctions here in terms of the Rome Statute, would be better known as a lex specialis, a subcategory of international law that has a specific binding effect between these parties. Very importantly, for example, it binds the states to accept the jurisprudence of the court in The Hague as binding on all states parties. That is precisely the opposite of the Genocide Convention. The Genocide Convention is only binding on states with regard to any determinations made under Article 9 of the International Court of Justice according to the rules of the court. And the rules of the court are explicit that in contentious disputes, they are binding only on the two parties. They are not binding on other parties. More than that, the Rome Statute makes express that decisions of the International Criminal Court are not binding or do not have any effect with regard to state responsibility. So you've got to get that out of your head, that the Rome Court, the Rome Statute Court, the International Criminal Court, makes determinations. And this is one of the conflations, or contributes to conflations, frequently made, where actors are quoting ICC decisions as binding on states with regard to state responsibility. They are not. They are explicitly Article 10 of the Rome Statute, not applicable. With regard to the law of state responsibility, for those who study public international law, it's a category of an area of international law, essentially addresses wrongs. And in this regard, I'll say some more things about it. But we have not only the Vienna Convention on Law of Treaties, we have some further interpretation, which is so far not strictly binding, but has been elaborated by the International Law Commission. Now, you need to know that the International Law Commission is a body established by the Charter of the United Nations, Article 13, and is the authoritative body of scholars, of jurists appointed, elected actually, by member states, a body of them, for the purposes of not only advising upon or giving views upon, but elaborating the progressive development of international law. And they, in 2001, I can't remember, it's 2001, adopted a body, kind of probably a precursor to a draft treaty, on the law of state responsibility, and gives us certain understandings and meanings that are, I say, not strictly binding, but are as close to authoritative as we have less than a binding instrument of international law. Again, remembering that the International Court of Justice is not binding beyond the contentious parties in a contentious dispute. Okay, those are my prefatory remarks. Now, I also want to distinguish something about crimes, because this is a major confusion. In public international law, and the International Law Commission has actually considered this, the state does not commit crimes. In fact, the notion of crime in criminal law is not applicable as a framework with regard to the state relations. And in international law, an individual may commit crime, both domestically, under domestic law, but even under international law. There is another lex specialis, or subsidiary body of international law, known as international criminal law. That is not about the conduct of states, it is about individuals. So, first of all, just in terms of what crimes are, they are offenses or wrongs which are prosecutable, and a state is not prosecutable or punishable in the sense of prosecution of a crime. So you may hear this all the time, for example, the International Court of Justice, that South Africa is prosecuting Israel. No, they are not. There is no prosecution. There is a dispute. And that dispute is being adjudicated according to the rules of international law between two individual states that are bound under private obligations. And in the case of the Genocide Convention, Article 9 explicitly provides that in the case of a dispute, parties shall refer the matter to the International Court. It's a mandatory obligation. Some states have placed reservations on this, for instance, China. So China cannot be brought to the International Court of Justice for a dispute by other states. And there is an open question whether a reservation to this treaty or to such treaties is actually permissible in the spirit of the instrument. And some people have written about this, but I can say to this point in time, there's no definitive determination in public international law whether that is or is not correct. As a matter of fact, many states have reservations of this kind. And not only for the Genocide Convention, there's an argument in human rights law that certain kinds of treaties are neither renounceable nor permissible for substantive reservations. Some people say maybe procedural. In this case, by the way, a reference to Article 9 to the International Court of Justice, of course, would be a procedural reservation. So that's an open question, but in any case, it's not prosecutable and it's not punishable. It's not what the International Court of Justice does. Criminal justice, just to say, is an important thing to take apart too, because we have a tendency when we talk about this to immediately think about justice in terms of retribution. And not only retribution, we immediately think about judicial recourses and criminal recourses. We're not thinking about the other forms of justice. And I want to just put in your head that if we're going to talk about genocide and the character of disputes, we're probably going to think about intercommunity relations, we're probably going to think about periods of time of scale and kind of the character of relations, that the idea that a retributive reference in terms of justice is sufficient, I would argue is insufficient. You're going to want to think about things like restorative justice or rehabilitative justice and so forth. Okay, so as I indicate here, in international law, crimes comprise a limited corpus of only individual natural persons. That's again not me saying, I'm quoting from the Rome Statute, for example, that could be prosecuted, not states. Let's also understand, in the case of a criminal prosecution of an individual, the consequences are principally punishment in the form of incarceration, and very little, if at all possible, repair. In public international law with regard to states, not only it's not even sensible to talk about the arrest and incarceration of a state. It's fantastic.
Fantastical.
Fantastical, thank you, as an idea. But people talk about this. It's an absurdity. So what you can do with states, and in the law of state responsibility that is very meaningful, is repair. And the law of responsibility, state responsibility, international law, is a duty, first of all, to accept and to declare the non-recurrence and to take steps to ensure the non-recurrence and to repair the wrong. And reparation is a very wide concept, can move from anything from apology to material repair, compensation, and so forth. So I just want you to understand, these are radically different approaches, and we shouldn't be confusing them in actual situations. Okay, so what is it that the state does if it breaches the Genocide Convention? It commits a violation. The International Law Commission has made clear you can only really, they interchangeably use the word breach or violation. A violation breach. That's the extent of it. And this is linked then to not only the duties on the wrongdoer, but entitlements to the injured parties. There are steps they may take, which I won't go into now. Within all of this, the Genocide Convention, again, I want to come back to, has this fairly unique in international law, and maybe Professor Short can confirm whether it really is unique, but it's fairly unique, duty to prevent, this a priori obligation. And it's a distinct obligation that entails appropriate conduct of the state, of all states, across a range of issues and law. Things that should be done to achieve the outcome, the realization, to give meaning to this explicit undertaking. And I would argue that very little has been done on this ever since this convention has ever been adopted. And we're not therefore surprised that we continue to fail to prevent genocides and we deal instead, or confront instead, the consequences. Next slide, please. Okay, let's just staying in the positive international law, we're talking about treaties, let's just take a quick look at some situations that might be relevant, and where is the actual binding character on the free volition, the consent of states to be bound. So I've just named a number of cases that are kind of popular, or maybe we could talk about different kinds. So I won't go through them all, but you can immediately imagine in your mind whether we're talking about indigenous communities or groups. So we know the Genocide Convention aims to protect specific groups, and this is a kind of distinctive character, and it identifies the kind of groups, but it does not elaborate criteria for their determination. So this is one of the problematical aspects of the Genocide Convention. We can go into some of the preparatory works and so forth, and this brings us into a lot of complex discussions and might view errors around what is sometimes called cultural genocide or other things. Whereas I will stay again with the positive international and simply say that these groups are identified and that you should apply to Vienna Conventional Law of Treaties to understand what they would be as subjects of protection. And if we look at the obligations, we see, and I put the list of Genocide Convention, I don't remember if I put the date of signature or date of ratification, which of course is also significant in international law. But in any event, the volonté of the state to be bound under the Genocide Convention, and then under the Rome Statute, and a number of states that have, and other states that have not. I have indicated there are a couple of interesting elements of how states have become bound under the Rome Statute, because for some contemporary cases, it's significant to note that, for example, the United States of America signed the Rome Statute in 2000, became a party, and then withdrew from it a couple of years later. Israel did a similar thing. That has consequences in international law, and so we can talk about that. But you should also note that the state of Palestine bound itself under both of these instruments in 2014, 2015. This has nothing to do with the recognition of Palestine by the United Kingdom or Canada. Get that out of your head. Under the lex specialis of the Rome Statute regime, the state of Palestine is a state and is a party, and this has been adjudicated by the International Criminal Court, what its duties are. And so for states like Canada, I'm not sure about the United Kingdom, Israel, US, who therefore say Palestine, they're not bound because they don't recognize Palestine. Sorry, under the regime of the Rome Statute, Palestine is a state, and Palestine is defined for that with regard to its territory, its population. So there is applicable law under the Rome Statute that cannot be withdrawn by Israel or Canada or someone else simply because they don't recognize. So just to understand what is the positive law obligations, this is a little chart, and we could talk about what this means later. Next slide, please. Okay, so to understand the definition of violation. So Raphael Lemkin, who was this, how to describe him? He's from Lvov in Poland, Ukraine, Jewish jurist, scholar, coined this term famously, genocide, in a reference to homicide, so a group. And he had within this idea the intentionality or the intentional killing or destroying of a group, but not only the killing. And he was explicit about this. I'm sure Professor Short can elaborate more than I can. But if we think about what it really was, it's an aggravated harm. The harms, if you read Article 2, are already harms and actually already violations of international law. But so there is no right to take life arbitrarily and so forth. But in their particular form, with regard to a group and with the particular intent, this becomes an aggravation. So you can imagine this in other kind of equivalents. And of course, his reference point was the Holocaust, but not only the Holocaust. The Holocaust was the most immediate impetus for it. As I say, the Convention on the Prevention and Punishment of Crime of Genocide is then elaborated. States take this up after the Second World War and adopt this article. Now I believe 153 states parties, so 3/4 of the world. Article 1 includes this duty to prevent, this what we often talk about, the never again. But I also want to understand, want you to note, it explicitly applies in time of war or in peace. So also get out of your head that this is somehow necessarily related to wars or something like that. It's not. Genocide can take place, is taking place, in my view, in certain parts of the world where there is no armed conflict, there is no war. In my view, actually now, there are breaches of this convention taking place. Article 1 does speak about commission, and Article 2, and articulates them. And you will see in Article 2, again, just that we are crystal clear about this, killing is only paragraph A. Now, this ordering, A to E, are not a hierarchy. They are not indicated as A must come before. It would be absurd to say that you must kill before you can remove a child. I mean, that would be an oxymoronic or illogical thing. Obviously, the subsequent violations would be before you kill someone. So killing is not the supraordinate standard. There is no hierarchy. It is one of a series of different violations. And you do not need to kill. You do not need to breach Article 2A in order for you to have breached Article 2E. They are separate violations. So you can commit genocide without killing a single person. Now, this is one of the main mistakes. A lot of people argue you have to have killing, you have to have a lot of killing. We had with some colleagues an argument with The Economist over this some years ago, where The Economist was arguing you have to have a bunch of killing, and it has to be the aim is eradication. This has nothing, is nowhere in the convention. And we know now that there are cases, for example, in Ukraine and Russia, where the forcible removement, transfer of children, and it's not just from one state to another, from one group to another. It alone constitutes a violation of this convention. Okay, next point. Just to go back, it also doesn't say anything about physical harm. So if you look at Article 2B, causing serious bodily or mental harm, or is clearly disjunctive. Otherwise, there's no point in mentioning mental harm. But we also know that there are specific forms of mental harms that are very harmful, distinct from bodily harm, which might relate, for example, to 2E. Okay, so that's violations. Another level of violations, I've already mentioned, Article 3, non-commission, but these other elements, which are punishable acts, really with regard to individual criminal responsibility, genocide, but also conspiracy to commit genocide, direct and public incitement to commit genocide, attempt to commit genocide, and complicity in genocide. All of those are also violations of the convention, not just the commission. I don't have to commit genocide to have breached the Genocide Convention. I could just simply be inciting it. I shouldn't say simply, but I could be inciting it. Article 4 speaks about the duty to punish individuals, natural persons, including constitutionally responsible rulers, public officials, or private individuals. So there's a gambit there of authority they may or may not hold that may be punishable. Article 5, contracting parties undertake to enact the necessary legislation, which is a breadth. That's not just criminalization. So a lot of countries like Canada, you will see almost expresses verbis terminology from the Genocide Convention in Canada's criminal code. But there are duties beyond that that the state should be doing in order to give effect to the provisions of the present convention. Rome Statute, Article 6, is identical to Article 2 of the Genocide Convention. But then Article 25, interestingly, indicates individual criminal responsibility. For example, commissions, orders, solicits, induces, aids, abets, assists, provides the means, facilitates it, elongates or enlarges explicitly the kinds of conduct. And this was, of course, decades after different experiences. So we have more specificity in the Rome Statute. Next slide. Okay, here's a little comparative chart. By the way, I'll make available happily the PowerPoint. So if you just want to go through a quick chart distinguishing the character viewed through judicial recourses, what would you have in the case of an ICC recourse versus an International Court of Justice recourse? So just to be clear, in the ICC, you have accountability of individuals. In the ICJ, you have disputes of states. ICC is individual responsibility seeking culpability. In the ICJ, you're looking at the state's responsibility, wrongdoing, determination of wrongdoing. The ICC requires state consent or UN Security Council reference for it to act. The ICJ requires state consent. There is no possibility of reference. You can have an advisory opinion, but for a contentious case, it must be an application from one state against another, which is very important because there's an argument made that state in this country, among others, that the state cannot act unless or until a prior determination by a court of law. Let me just suggest that is lunacy, logically, but it is exactly contrary to the way the International Court, in order for the court to adjudicate, somebody must bring an application asserting that there's a breach. And if they're waiting for a prior determination, this is illogical. You can't get to the court unless you've already made your conclusion, you believe, and then you've presented it and you have a dispute. The ICC requires criminal charges or case. The ICJ just requires a dispute. You have to establish you have a dispute. The ICC then is a prosecution. You have a prosecutor, Office of the Prosecutor. ICJ has no prosecution, and there is no criminal law. There's no criminal law elements in the ICJ. It's not a criminal jurisdiction. And does not include things, for example, presumption of innocence. A state is not presumed innocent. A state has no human rights, not even to due process of law. They follow the international law established. ICC requires a trial by arrest. They have varied this a little bit, now talking about in absentia. I think this is highly problematical. And the ICC would have a finding of innocence or guilt. ICJ requires an application and possibly finds a breach or violation. The ICC results in possible imprisonment and minor, if any, reparations, and I'll come to this in a moment, but there may be actions which no individual had ever done or could ever have done that still constitute genocide. So, and are not possible for any individual to repair. So the whole reparation idea is basically not applicable for prosecutions of individuals. The ICJ requires, in terms of state responsibility, a finding of a breach. The state would be subject to orders, usually of certain specific performance. Don't do this, do that. An obligation of non-recurrence and of repair. Very, very important. The Rome Statute has no provision for interim or provisional measures. What would you do? There's no duty to prevent either. But the International Court of Justice has a very important capacity for interim or provisional measures that can be very powerful. Okay, so quite important to get our heads straight. Now, I'll just be very brief on this international law of state responsibility, since a lot of people get confused about this. This doesn't mean moral responsibility. We're a father, you behave in a responsible way. That's not what international law means. So international law of state responsibility is a second order of rules with regard to wrongs and remedies. I've mentioned some of them already. It's a lex generalis, not a lex specialis. It applies across the board to all of international law. It comprises essentially 4 elements: the qualification of a wrong, the attribution. So in international law, we're not assigning guilt or anything. We're looking at is the state, is the act or the conduct, more specifically, attributable to the state? And certain things are presumptively attributable to the state. So it might surprise you, but words spoken by a head of state or head of government are presumptively attributable to the state. This is one of the problems we have with Donald Trump. He started tweeting, and as head of state, every single one of his tweets is an act of state, which is hugely confusing, because sometimes he tweets like a bat out of whatever, and we're not sure what that means, but it is an act of state, for which incidentally he has immunity. So but attribution is the second part. General defenses of liability exist. For example, mistake, or it may be, for example, the absence of effective control over territory, or there may be agents of the state who are presumptively attributable, armed forces, but if they act demonstrably contrary to orders, you might say the state is not liable now because we have a certain excuse. There's been what do you call it? For example, on a ship, naval marines could take over the ship, and then the ship still flagged by the state. You might say, oh, it's attributable to the state, but it's not. There's an excuse. So there are some excuses, and of course the fourth category is consequences. That's all important just to say the Genocide Convention and the obligations under genocide on the whole do not admit, and we could discuss this in more detail, do not admit to excuses. There is the high standard of presumption with regard to the duties under the Genocide Convention, in my opinion. Otherwise, it becomes very problematical. Remedies entail duties of repair and non-repetition, I indicate these. And they also include measures of self-help, including measures which might otherwise be unlawful. So there's this notion international called retortion. So I may be prohibited, for example, according to a trade agreement, from taking certain measures. But if I'm responding to a prior wrong by you, I may be permitted to take those measures if they are targeted, proportionate, limited, and so forth. These are the rules of state responsibility. Breaches of jus cogens, and the prohibition of genocide is a jus cogens obligation, are obligations owed to non-state actors, are also obligations are omnes, owed to the international community as a whole, for which the state may act and seek repair. Okay, so to act also with regard to non-state actors. Yep. Okay, so quick summary of the Convention on the Prevention and Punishment of the Crime of Genocide. Here's a dozen or so key elements I wish for your attention. If we're again thinking about what is it this instrument is supposed to be doing. So first of all, it's a treaty like others. So please stop thinking about it as a special treaty. International law does not have a hierarchy of special and non-special treaties. It just has treaties. It's actually an easy one. It's a total of 19 provisions, 9 short substantive, 443 words. It's not a complicated treaty. One of the indicative elements is this aggravation element, which is really about intent, which often consumes a lot of time, interest. It applies in time of peace or war, so it's not just about armed conflict. People often conflate war crimes, genocide. It has this very important duty to prevent, an anticipatory obligation, which is really about risk. And so if you know anything about anticipatory obligations, they are essentially risk assessments, and the International Court of Justice has actually adjudicated this. The International Court has said that the duty to prevent starts at the point in time that a state knows or ought reasonably to know that there is a serious risk of genocide occurring. It has to be in advance. So the idea that you have to prove in a court a genocide before you have a duty, which, by the way, a number of very well-known scholars and others argue, is patently absurd. You can't do it. It's got to be a risk analysis. Duty to prevent entails forbearance, things you should not do, but also positive conduct, actions you should take, including vis-a-vis third parties. And the International Court of Justice has again said the duty to prevent is owed by the state that is in a position to act with reasonable proximity, with capacity, and so forth. So basically, if you're nearer, closer, more powerful, more able, you actually have, in positive terms, a higher obligation to act. If you're St. Lucia in the Caribbean and you're nowhere near Darfur and you have no agents, probably your material duty is less than a neighboring state or a state that provides resources like UAE and others. I won't go through all of these in terms of the definition. The prescriptions we've seen, they include conspiracy, incitement, many other things. There is a duty to punish potentially culpable, punish culpable individual, natural persons. A duty to incorporate domestic law, again, which many states have not done. For example, Myanmar has never incorporated in its domestic law the prohibition of genocide. So you cannot prosecute a person under Myanmar law for genocide. Cannot do it. It doesn't exist. And it would be problematical in terms of retroactive justice to adopt the law today and prosecute them for acts, previous acts. That, I won't go into detail, but there's a whole pile of attendant problematical aspects of that. But what we can say is Myanmar, which is a party to the Genocide Convention, is therefore in breach of Article 5 of the Genocide Convention. That alone. Whether they commit any act or nothing else, they just haven't done what they should do to prevent. A duty to prosecute, and that implicates human rights, because an individual natural person has human rights, such as to due process, a right to a fair trial, presumption of innocence, a defense, and so forth, vigorous defense. There is a duty to extradite, which is very important. A number of states do not extradite. And a state prerogative to call upon UN organs. This has almost never been used. But the state is not bound to effect its duty to prevent alone. It may use its position as a state to call upon other actors, including the United Nations organs and others, to assist. Right now, there are very interesting discussions in Syria with regard to transitional justice and other things. Is Syria capable, even if it had the volition? But it's certainly capable to call upon other actors and to seek assistance, including United Nations bodies and others. And not only with a retrospective perspective, but with a prospective perspective if they want to act to stop the potential of a retributive act, self-help by different actors in the state in these very terrible contentious situations. And there's a duty to settle disputes peacefully at the International Court of Justice. That's generally by. Next slide, please. Here are a few conflations. I've mentioned a few already. So I'll just repeat. These are common mistakes, confusions, often with criminal law, international criminal law. The state cannot commit crimes. It's just a misconception. The state has mens rea. Even the International Court of Justice has used this term. The state does not have a mind. And that's why international law focuses on attribution, conduct. And for that purpose, words spoken, written, articulated are considered acts. They are conduct. Voting in the United Nations is a conduct of the state. It's not just the words, it is the action. And so what we're looking at, because we can't imagine effective international relations if we're continually having to think, does Trump mean what he says? You know, is there someone behind? He said yesterday that he had no idea of someone he's just pardoned, this cyber currency guy. And now are we supposed to assume, okay, who then pardoned him? Well, we can't live in that world in international law. We need a reliability. So international law focuses on attribution. What is the state actually doing? And we assume that the state intends, the state intends the conduct, its own conduct. The state can, at international, be prosecuted. That's not true. And penalized? Well, that's also not true, not penalized. It can be subjected to obligations of repair and also exclusion and so forth, which in kind of common parlance you might think of as a penalty, but not literally criminal sanction. International criminal law applies to the state, and international criminal law, specifically the Rome Statute, explicitly does not. So Article 10 of the International Criminal Court here, I'm quoting it for you, nothing in this part, the obligations, shall be interpreted as limiting or prejudicing in any way existing or developing rules of international law for the purposes other than this statute, meaning international, individual obligations. I think the last slide I have. Mm-hmm. So these are popular errors of interpretation, and you will have heard them. No one needs to be killed or die for there to be a breach of the Genocide Convention. More than that, very well-known people, one of our compatriots, Professor Bill Shavis, is somewhat, I would say, infamous, for a long time saying there needed to be a minimum of 10,000 deaths. First of all, that's a real number. There's no context or anything. So, if you have millions and millions of people, we're not sure what 10,000 is. But let me suggest to you, think for a moment about the Sami in Finland. The total number of the Sami population is less than 10,000. So according to Professor Shavis, there can never be a genocide against the Sami because you would never have 10,000 deaths. The whole proposition is wrong. You don't need a single person to die, never mind a threshold. There is no threshold numerically, never mind that a real number rather than a proportion, and so it does not even necessarily indicate intent deductively. There is no stipulated threshold or application for application implementation at all. There is no threshold. Any of these acts with this intent. And by the way, an individual under individual criminal responsibility may be subject to conduct which constitutes a violation of genocide by their intent individually. And I think there are many cases where you have such instances. That's different than the state. And you may have a situation where you have simultaneously the state and individuals who are breaching individual criminal obligation and state obligation, if you can establish it. There is no required amount of time or duration or limitation in time or duration. This is also important for the Genocide Convention. So there's no limitation, a statute limitation to it. There's no time over which, for example, the conduct must occur. So it is possible to imagine what some people have called, not instant, I'm trying to remember the correct term, but for example, the use of a nuclear weapon to wipe out could be an instantaneous genocide. There is no hierarchy of harms or breaches. Article 2 and Article 3 are not in hierarchical order. There are no conditions precedent, nor prior determinations are required. So this is this nonsense, I have to say, in this country, that you need some court, and they go through contortions to get an act of parliament, which is absurd, to have some domestic court decide whether the government as such can decide. This is just trying to skirt the obligation. And by the way, other states are not going to give a damn what a domestic court says. I mean, I don't think Canada would care if Rwanda's domestic courts decide something. They're going to look at the state. The Genocide Convention stipulates intent. It does not stipulate special intent. We don't have time to go into this right now. But it does not stipulate special intent. This is a post facto construction. But in any law for conduct, intent, and especially if you think about domestic criminal law, it's extremely rare that anybody declares, I'm declaring why I'm hitting you on the head or why I'm walking into. Normally, we determine intent through the corroboration, through corroborative acts, a smoking gun, a statement, a testimony, or documentary evidence. So in international law with regard to state responsibility, it's been well established that a pattern of conduct may establish intent. Well, I would suggest to you it's almost the only way you're going to understand if there's intent. But if there is strong evidence of physical act together with declared statements, then I would say you're in a very, very strong presumptive position of intent. We don't do the opposite and say, no, they don't mean what they say, they don't mean what they're doing. We should assume the opposite. There is no requirement of sole purpose. This is another argument which has been made, which is absurd and neither stipulated nor logical. So the argument has been made that there can only be a breach of genocide in commission if the only intent is to destroy. Now, that means the Holocaust would not be a genocide. Because the Holocaust was also about Lebensraum, it was also about many other things. And if you just think again about domestic criminal law or other areas, almost nobody does things for a single purpose. We often do things for many purposes. But it has absolutely nothing to do with the Genocide Convention. It's nowhere deductively nor explicitly. The Genocide Convention is not explicitly limited. It's not limited to physical or biological destruction. This is another thing you will see in a lot of the literature. I've already pointed out that Article 2 explicitly foresees mental harm. Article 2E is not a physical destruction, and so forth. But clearly it's not part of the object. If you can destroy a group, I'm deeply worried about the Rohingya, for example. 85% of Rohingya have been removed from their homelands. They've been dispersed around the world. Their linguistic and cultural coherence as a community is dissolving. There are many Rohingya around the world who no longer speak Rohingya language. They have not been back, never seen their homeland, and so forth. My own concern is one more generation, and there may be 3 million people who are, might identify as Rohingya, but there'll be very little coherent community that remains of the group. So I think we again have to think about what is the harm, what are we trying to do? And finally, there's no stipulated standard of proof, and never mind an onerous one beyond a reasonable doubt. In public international law, state responsibility is not predicated on a beyond a reasonable doubt standard. That's a criminal law standard. It is used in human rights, the European Court of Human Rights, but in regard to individual cases. But between states, the normal standard is preponderance of evidence. The International Court of Justice has not resolved this. If you look at it, the International Court of Justice is all over the map. I think they give 25 different explanations, but it's clearly not beyond a reasonable doubt. And the reason it's not beyond a reasonable doubt, because the duty to prevent will always have a reasonable doubt, because it's a risk analysis that is not susceptible to such an exacting standard. Okay, I think maybe, is there one more, or no, that's it. So I haven't mentioned really any individual cases. It was my intent not to mention them. I wanted to partly deconstruct the idea of genocide and the kind of instruments we have in positive international law. And I wanted us to go back to, and I will end with this, that if the fundamental idea is never a gain, the emphasis must be on prevention. And prevention must be fundamentally about state conduct. The state has the capacity to do this. And if we do look at almost any genocide case in the world, whether it's accused or suggested or genocidal, it's not that there are some individuals who have heinous, or hate-filled. It's that they have been facilitated by states. If you look at the wonderful work of Dr. Gregory Stanton and Genocide Watch and so forth, he elaborated something called 10 stages of genocide. But what I would suggest to you, if you look at these cases, they are foreseeable. And they overwhelmingly turn on the facilitation or at least the tolerance of the state, meaning that there are enormous opportunities and moments of conduct where the state can prevent what becomes a genocide. And this is where we need to turn our attention. Thank you. So now I'm interested to hear what a real expert.
Thank you so much, John, for talking us through a really detailed look at the law, but making it accessible. And I think at a time when genocide is such a highly contentious political topic at the moment, I think it's important to go back to what is the letter of the law and how can we interpret that fairly. So we're very lucky that we have another genocide scholar in our midst here. I'm very pleased to welcome.
A longer, better one, I have to say. It's written a book or two, actually.
He has, yeah, and expanded the concept in interesting ways. So
yes.
Professor Damien Short is our colleague here at the Institute of Commonwealth Studies, Professor of Human Rights and Environmental Justice. He's also co-director of the Human Rights Consortium here and the Environmental Humanities Research Hub. He has researched and published extensively in areas of Indigenous peoples' rights, genocide studies, reconciliation, and environmental human rights, and he is an active member of the International Network of Genocide Scholars. Among his writing in genocide studies was a significant book entitled Redefining Genocide, Settler Colonialism, Social Death, and Ecocide. And that latter part gives you a hint into some of his more recent work, which has been looking at ecocide genocide nexus, and including trying to advance a bill on domestic law here on ecocide. And he leads our teaching of our master's degree module on genocide, mass human rights violations, and reconciliation. So really appreciate your time and reflections, Damien. So we'll hear a few points from Damien and a response from John, and then we'll go back to the audience.
Why don't you come and sit here?
Including
For the,
I'd like to see
but
We'll
it
get
is,
there.
I want you to be the focus, John.
okay, is it, I don't know if the camera is getting,
It'll
It's
zoom on
getting-
to
yeah,
Oh,
it's
wow,
getting
okay.
It's
everyone.
very active.
I have to
It's
say,
active.
there was a comment from someone online saying the camera is very
It's
dirty,
jumping
and I do
around.
apologize for that. I don't know how to fix that, and I know there was already a problem with the cameras. I
It's
don't
AI.
dare touch anything. But if it's really distracting, you could always just turn off your camera and listen in. So, Damien, please, you have the floor.
Great. Well, thanks, John. That was fantastic. It's great to hear some legal clarity. I think you're absolutely spot on to point out there's just so many errors made, willful misinterpretations in popular debate, possibly politically motivated, I think, sometimes. But I think it's fantastic. That was super clear, and I agree with everything you said.
oh, wow, okay. Okay, we should
no.
go now.
Yes. So what I would like to do, I think, for my little part, is to sort of tell a little story which will help contextualise a lot of what John said. And this is something that I've done in the book that Corinne mentioned, Redefining Genocide. And I did have a little bit of a battle with the publishers on this. I was saying, well, it's not really redefining it, it's taking it back to its original meaning.
Yes.
But they like the snazzy title of redefining a little bit more. But the other problem I had with that is it tended to feed into what happened with a lot of the scholarship after the convention, is that every single scholar engaged in it tried to make their own definition. And it really made errors much more likely. We went further and further away from Lemkin's original interpretation, and confusion ensued. And it really hasn't helped. So one way in which we can avoid making such errors is to do what John's done, is to look exactly at the law. The other thing to do, to appreciate how the law ended up looking like it does, is to look back at Lemkin's original work. And it is a fascinating endeavour, and it was one that I did largely because of Indigenous activists I was interviewing during my early PhD years, and they were all using the language of genocide to describe, as Larissa Barron put it, their lived experience as colonised peoples. They felt it was the best word to describe how they were living. And in Australia at the time, you had these sort of history wars, and there was a huge reaction to Indigenous peoples using this kind of language. And even some terrible quotations. I remember Kenneth Minogue argued once that Indigenous peoples and their more extreme movements have a tendency to exaggerate their suffering, he said, as forms of genocide. And so then what I wanted to do is to see which person was right. Was Larissa Barron right with her understanding, or Kenneth Minogue? So I went back to look at a lot of Lemkin's unpublished work, and there was the early work of Dirk Moses who was popularising this. There was only a few scholars at the time looking back at Lemkin's original work. And what was particularly important on this is that Lemkin's idea about this single word genocide came from two separate ones. It was barbarity and vandalism. So barbarity was the physical side, and as John's pointed out, that was just one side of it. The other side was the vandalism, which he was talking about cultural destruction. And then when he thought more about it, and came up with this single term, genocide, because he was very interested in the power of naming, and barbarity and vandalism were somewhat clunky ideas. So in that idea of genocide, it was basically emphasising the vital importance of cultural distinction, okay, to the whole idea of genos. So in other words, it's culture which animates the genos in genocide, right? And without that cultural understanding, the word loses its meaning. So if you understand it that way, then you can see that cultural destruction can occur through a variety of methods. And even though in his interventions in the UN and all the various committees he went through, and he was lobbying incredibly hard to have a very robust, broadly defined concept become law. And when you hear about the people describing how he was as a lobbyist, that he was so incredibly powerful and strong and determined. Many delegates would just run in the opposite direction when they saw him coming. He put so much into it in his life that he almost died several times during he is lobbying. It's quite an incredible story. I mean, he took himself right to the edge. And in so doing, unfortunately for him, there were a lot of political forces which, in many respects, I think, were worried about the fact that his idea had incredibly strong connections to colonization. In fact, in many ways, when you read his work, genocide was intrinsically linked to colonial processes. And there was worry among states what could happen if a fully fledged Lemkinian understanding of genocide became the law. So consequently, in these committees, it was somewhat diluted, such that the cultural method, and this is an important distinction as well, often you hear cultural genocide used as a different type. It's describing the methodology of genocide. So just like physical killing is just one method, it's one method by which a cultural group can be destroyed. Cultural eradication is also another very important method. And what you see in the convention, as John showed, is that killing is still only one. So despite the fact that he said, when the cultural method was largely eradicated from the convention, he said, I had to give up an idea that was, quote, very dear to me. And it was because of that culture animating the genus and genocide. In some respects, the heart of it was ripped out, but that doesn't mean it doesn't have coherence. What the law currently shows is a much broader concept than popular understandings. So you have the physical killing, it's just one. I mean, conditions of life calculated to bring about, I mean, it's a huge underutilized element. You know, and I think John's pointed that out really, really well. But then finally, you have the removal of children from one group to another, which is arguably the most cultural method left in the convention. So, connection with colonization, very, very important to understand. And then secondly, the different methodologies. They're not different forms or lesser forms. As John was pointing out, there's no hierarchy here. It's just a different set of methodologies. So as Corinne pointed out, one of the things that I've done with a number of other scholars more recently is to sort of in some way update Lemkin and say, this can often happen through environmental destruction too. And I also agree with John that there are probably, well, I can say guaranteed, many, many more genocides occurring if you understand genocide in Lemkin's original interpretation, which I would say is correct. Because as Dirk Moses points out, there are plenty of scholars who seek to instruct Lemkin retrospectively about his concepts. And what they're actually describing more often than not is mass murder. You know, we already have that. It's a different concept, right? So more often than not, I think people are just using the wrong concept sometimes. You know, genocide can involve physical killing, but also can be conducted through a variety of other methods. So I think, just to finish up then, I think one of the things that myself and Martin Crook in particular, and other scholars have done recently is to look at this genocide-ecocide nexus and to see how these conditions of life can come about through environmental destruction, forced removal from people's land bases, etc. And these are the kinds of genocidal episodes I think are occurring more numerously than we would realise if you just look at the popular press, for example, and even the UN documents, right? I mean, I think nowadays one of the main problems is a lot of these genocidal pressures are brought upon by capitalist development, extractive industries, etc., which are effectively polluting the land, forcing people to leave their land, polluting the rivers, etc., all of the land base on which many social groups depend for their very survival. So thinking about things like intent, etc., one of the barriers to looking at these things potentially as genocidal processes as well, you know, it's a byproduct of capitalist expansion. You know, but one of the things that really struck me as a human rights scholar coming into this field is, why aren't we prioritising the effects on the groups? Why are we obsessing about the perpetrator mentality? You know, and I found that really peculiar. If a group is experiencing genocidal impacts, then surely it's genocidal. Whereas the way the debates have gone and the way the obsession with understanding, misunderstanding the intent side of the Genocide Convention is that there's this obsession about perpetrator mentality. And as John pointed out, there's this suggestion it has to be like a singular understanding. I'll just finish by saying, touching on one of the points that John mentioned towards the end. One of the problems is there's this consistent conflation between intent and motive.
Oh, yeah.
That's the problem. You know, they're different things. Why you do something is different from intending to physically do it, right? And as John says, you have multiple motivations often. And that's why I always think you should be looking at the genocidal effects rather than the intent. Anyway, I shall stop there, but thanks for the very stimulating talk from.
Thank you so much, Damien, for bringing in that other perspective, and I think it brings to mind that how we understand anticipatory risk is broader, and if we bring in Damien's perspective on different methods that can come into play here in terms of genocide outcome.